Thank you for joining this Food Focus webinar. I'm now handing over to Janusz Luterek of Hahn & Hahn Attorneys.
Today's presentation is going to be about trade secrets and confidential information in new product development. The reason for this topic is that this has come up quite frequently in my practice, that companies pick up difficulties in relation to new products they've developed, new formulations, where staff have left, moved to other companies, and a situation arises which can lead to court action. So I think it is quite important that companies understand what their rights are and what, again, the obligations are if you happen to be one of the employees working in new product development. So intellectual property, just in a nutshell, comprises of what's in your head, which is the human capital, and what are the intellectual property assets of a company, which are things like patents, designs, copyright, and so on. So human capital cannot be owned by a company, but can be secured by a company, usually through a contract, and it's the employee's skills, abilities, knowledge, and know-how. The intellectual assets, on the other hand, are that knowledge which the employee had, which has now been reduced to a material form, for example, a trade secret, which is a recipe written down somewhere, and very importantly, a company owns it and a company controls it. So non-statutory IP, as we call it, is things like know-how, trade secrets, and confidential information. And why we call that non-statutory IP is there's no specific law in South Africa, unlike in other countries, where know-how or trade secrets or confidential information is specifically protected. Whereas there are laws for patents, registered designs, trademarks, and copyright. So to sum up, if you look at the whole picture of intellectual property, you get the statutory ones, which is where there are laws, where you go and register something, trademarks, patents, designs, copyright. You get the non-statutory ones, which are not registrable, which includes things like trade secrets and confidential information. I think you've got human capital, which is the know-how which the employees have, which can, of course, be converted into something like a trade secret or confidential information. So know-how and trade secrets are, in fact, slightly different. Know-how is the factual knowledge which an employee has, whereas trade secrets are already reduced to paper or nowadays, I suppose, electronic format, and you can, in fact, sell it. So you can sell a recipe, you can sell a formulation, you clearly can't sell an employee. So there are differences between know-how and trade secrets, but certainly trade secrets usually include know-how. And trade secrets need to be kept secret, which one would presume is obvious, but yet you find that not all companies understand this. How does one protect these things? Well, trade secrets must be protected through keeping them secret. You've got to have specific agreements in place, but the real risks there are that a third party could have a patent for something that you're keeping secret, and secondly, it can leak out. Know-how, the best way to protect it is to get the person who has the knowledge in his head to put it down on paper. You know, we sometimes speak about what would happen if you were run over by a bus. Well, if you're the only person with a certain know-how and you're run over by a bus, well, that will be the end of that know-how. And of course, once the know-how is written down, or I suppose even while it's in the employee's head still, they should treat it confidentially. And the way to do that is to educate the employees on the importance of keeping these things secret. So what are trade secrets? In a typical food business, trade secrets could be information regarding the equipment that is used, plant, processes, modifications that you've done. You know, maybe you're buying standard equipment, but then you're modifying it in some way, operational conditions, client information. And a client may come to you and say, I need you to develop a new recipe for me to make a fruit-flavored yogurt drink. So that client information could also be a trade secret. And of course, you could have databases which include trade secrets. The most typical ones where I often get involved in relate to recipes and formulations. where a company has developed a certain recipe and then they feel that a competitor has now taken this trade secret. And the obvious one that very few people think about are manuals. So manuals, once they are written up, if properly marked and properly stored, could also be considered as trade secrets. And the way to deal with all of these is they need to be marked as confidential or secret. You know, like James Bond did, for your eyes only type of thing. So where is it? Where is this trade secret? Well, it's often contained in documents, procedures, specifications, minutes of meetings, drawings, memos, correspondence, reports, manuals, databases, very importantly, with employees. And all these types of documents need to then be identified as confidential material so that somebody doesn't willingly or maybe unknowingly share it with someone or give it to someone. So let's quickly just clear up a few confusing terms before I carry on with the main part of the presentation. So know-how is the general knowledge, skill, and experience of a person. It's what's in your head. Confidential information, often technical, business, or marketing information. It could be files, it could be on a computer somewhere. Proprietary information could be confidential information, but it could be information which is developed by you for yourself. And then trade secrets is any of the above which have economic value and are not generally known. Now that last one is very important. Economic value and not generally known. And I'll get back to why that is important. So what are the guidelines when dealing with trade secrets? First of all, you need to identify confidential information and trade secrets. Once you've identified them, you need to keep the trade secrets or confidential information secret. It sounds obvious, it's called a trade secret. Take reasonable steps to keep the trade secrets and confidential information secret. When I say take reasonable steps, I mean mark the documents. Have proper access control. People must sign things in and sign things out. Computers must have folders which are not accessible to everybody unless they have a password, etc. There are certain technologies you may want to patent rather than try to keep them secret because it may not be possible to keep them secret if they are used openly, say, within a factory. And then, of course, you want to evaluate the non-statutory intellectual property so you know what it's worth. Remember what I said in my previous slide, that a trade secret must have economic value and not be generally known. So by evaluating it, you can show that it's got value. So how does one identify confidential information? So first of all, you could have confidentiality agreements with customers, and there you would identify specific materials. I am not a proponent of general clauses. For example, everything that we deal with is confidential, or you will keep everything that you know about that we do confidential. Clauses like that are non-starter. Confidentiality is agreements with suppliers as opposed to with your customers. There you need to ensure that they keep your information secure, because quite often you are telling your suppliers what your plans are, what your formulations are, because they need to have input. And it's important that they keep that information secure. Then we have confidential clauses with employees. Now, those of you who know of Snowden, you'll know that although he was just an employee of the NSA, he knew everything. So just remember, employees need in their employment contracts to have confidentiality clauses that they won't disclose anything they learn during the course of their employment. And then finally, the one that comes up quite often is restraint of trade agreements on directors and possibly senior employees. And the reason for that is that you don't want somebody, and I dealt with a matter like this not too long ago, a director leaves a company, sets up his own company in direct competition with his previous company, using the confidential information and trade secrets which he had learned over time at his previous company. How does one keep it secret? Because that's, of course, $1 million question. So first of all, you need to mark all your documents as being confidential, the sort of for your eyes only, as James Bond would say. Limit distribution of confidential information. Don't let it just be available in a library or somewhere on a shelf in a lever arch file where anybody can get to it. Keep a register. Make people sign it in and sign it out so that you know who has had access. If it's electronic, you can have a log of who's opened and accessed a file. You want version control on files. You want track changes so you can see who's changed what, and you want initials to really be able to get to the bottom of who changed what. All employees must be reminded of the duty to keep things secret. All employees that are new employees, at the time that they are signed up, must be given an initiation on keeping things secret and confidential. And unfortunately, the last one has to take place. If you find somebody is not treating information as secret or confidential, you must take action against them. Failure to take action against them will result in the information not being confidential or secret. What do I mean by this? You cannot go to court and say, somebody has stolen my secret information and it's really valuable. But on the other hand, when somebody previously took your information, you did nothing about it. It can't be valuable now when you didn't consider it valuable last week. What are the reasonable steps required to be taken in order for information to be considered as trade secrets or as confidential? Well, you need to take reasonable steps to keep it as such, otherwise you will lose that status. You need to ensure that all persons in contact with the confidential secret information understand it is secret and valuable, and that you will take action. In other words, you will enforce your rights. Those three words are key. They need to understand it's secret, it's valuable, and there will be enforcement should it leak out. You need to limit access to folders on servers, probably using encryption. You need to screen employees for criminal past before they have access to this type of information. And those of you who know of the Protection of Personal Information Act, so-called POPI, a lot of systems were included there for how you keep personal information secret and how you protect it. And if you apply those principles to your confidential and secret information, it will probably be enough.
Janusz, so it seems that there's a lot of responsibilities on the manufacturer to protect their own intellectual property. But what about patents? Where can something like that be used, and what is the kind of protection that you get for that? Sure.
So that's a very good question. So historically, many companies have kept formulations and recipes and process changes and so on secret and considered them to be trade secrets. Now, in the days when everything was written in a book and you could lock a book in a safe and you knew it was secure, I suppose it was possible to keep a secret for 100 years. The difficulty today is that, first of all, everything is electronic, so somebody can email a recipe to someone, even maybe by mistake. They can use their phone and photograph something and send it out. I suppose more importantly, there are very advanced analytical processes. So somebody can buy your product that's made according to a secret recipe, do an extensive analysis and know how it was made and what went into it. And the only way to protect against that is in fact through patenting your product or your technology. There are limitations, however. So a patent is really the only sure way to protect products and technologies, but it's limited to 20 years. So once you have your patent, you will have protection for 20 years. Whereas a trade secret well kept, like the Coca-Cola recipe or the secret recipe of KFC, etc., potentially can be forever, or for as long as you manage to keep it secret. Trade secrets, as I say, and confidential information have infinite protection, subject to you being able to keep it secret. A patent, however, has one big advantage. It forces somebody to sit down and to write up what is it they have invented. Now, that process in itself is very important because remember my explanation, the difference between know-how and a trade secret. If you have know-how in someone's head and they get hit by the proverbial bus, it's gone. But if you have forced them to write it down because you're going to file for a patent, that it's no longer tied to that person. It's now stands on its own and it exists in its own right. So even if you choose not to file a patent, but to keep your recipe or your formulation or your process secret or confidential, it is still a good idea to write it up as if it were going to be a patent, because at least you will have a very extensive scientific legal record of what it is that your confidential information encompasses. And finally, very importantly, it's only possible to patent something while it is secret, which means you cannot start selling a product, say, well, this sells really, really well, I think I need protection, and then try to get a patent for it. If you're going to file a patent, it's a decision you have to make right in the beginning. And if you then decide, I want to do a patent, you file the patent before you start selling the product.
And then, sorry, on that as well, I see you're going to talk about non-disclosure agreements. Can this protect you if someone steals your ideas?
So non-disclosure agreements are loved by lawyers and many people in industry. I have people coming to my office or emailing me regularly saying, I'm going to see so-and-so, I would like an NDA. Or please email me an NDA that I can use for my meeting. Now, first of all, many of them believe an NDA is a one-size-fits-all. It's a type of document that says everything I'm going to tell you at our meeting is going to be secret. And I regret to tell you that's not worth the paper it's written on. Why is it not worth the paper it's written on? Because at the end of the day, who's going to say what was discussed in the meeting unless you have a video recording or some other way of properly recording what was discussed in that meeting? To simply say everything we've discussed is confidential is meaningless. So you need to specify what has been disclosed, what is going to be kept secret, and for how long. That process itself, of course, results in you having to write up everything which you're going to be disclosing. You then would attach it as an annexure with a detailed description, and the parties to the non-disclosure agreement will then sign the agreement as well as every page of the annexure. Now you possibly have something which binds the parties to the NDA. But what is the problem with this? The problem is it only binds the parties to the NDA. So a third party who never signed the NDA is not bound by it. You could find a third party starts making your product, but they never signed the NDA, so you have no protection. Of course, there are consequences if an NDA is breached, but those consequences are contract law. So you would have to sue someone for breach of contract if they breach the NDA. And then, of course, the one I see all the time with NDAs is, Dr. Google, as they call him. Well, you also get lawyer Google. People Google, they want an NDA, and they simply download an NDA from probably someone in the USA, and they simply put their name in at the top, and now they think that they've got an NDA. The problem is, of course, that NDA would have been drafted in terms of American law, and to make life more complicated, America has 50 states, and the law differs even from state to state. And I frequently see NDAs that refer to the law of Delaware or of some other state. It talks about jury trials and so on. So do not download an NDA off the internet and use it if it is not drafted in terms of South African law. So an NDA, in any event, needs to be reasonable in various respects. It needs to be reasonable in scope, in period, in area. Remember that when you're dealing with an employee that's signing an NDA, the employee does have a right to earn a living. And the employee's obligation to maintain confidentiality should be for a prescribed period, maybe 1 year, maybe 2 years. Certainly can't be forever. And then, of course, you've got to say, well, where will this apply? Will it apply to the whole country? Will it apply only to a part of the country? Those are all the things that need to be considered in an NDA. What are the consequences of breaching an NDA or a restraint of trade by an employee? Well, if it's in terms of an employment contract, you may have to hold disciplinary hearings or have disciplinary procedures. You may have to threaten to sue the employee or the person who's in breach of the restraint, possibly claim damages and legal costs against them. Remember, you have no right to stop an employee from earning a living, but the more the employee is paid and the more senior they are, the greater restraint can be placed on an employee. I recently was involved in a matter where a fairly low-level employee was suspected of having taken a formulation with them when they left their company and went to a competitor. And to my surprise, the court held that even that low-level employee was restrained and had issued an interdict against the new employer, preventing the new employer from making a product which used the information from the new employee. Of course, if you're the director, you have the highest degree of obligation to keep things secret. So it's probably easier to stop a director who goes away with your confidential information than a low-level employee. What are examples of things that can appear in one of these agreements? So first of all, the recipient can irrevocably and unconditionally undertake to treat and safeguard confidential information as strictly private, secret, and confidential. So that is a good clause in an NDA. It makes it clear that things will be kept strictly secret and confidential. Another important clause is an undertaking not to analyze or reverse engineer or otherwise modify, adapt, alter, or vary the whole or any part of the confidential information. So if I give you a sample of a product, that person can't go off, analyze it, and then try to work back, well, how was this product made, and then start competing with you. And then, of course, they give an undertaking not to copy or reproduce it. Another important clause which appears often is to keep all confidential information safely and securely, and to take all such steps as may be reasonably necessary to protect it against theft, damage, loss, unauthorized access, and to prevent confidential information from falling into the hands of unauthorized third parties. So this would often apply if you're a contractor. So you're a contractor working inside a big company. They would require you to sign a clause like that because they want to make sure that your employees don't run off with their information, if you know what I'm saying. So if I'm a company that builds pasteurizers, but you've developed a new product, you don't want my employees that are building the pasteurizer from seeing how you make your product and going and telling somebody else. There should be a requirement to return or destroy all confidential information at the end of the cooperation or when the employee leaves. Destroy all analyses, compilations, notes, studies, memoranda, or other documents prepared which contain or otherwise reflect or are generated from confidential information. And then, of course, there should be a clause that if you're not sure if something is confidential, treat it as confidential. And finally, the only time that you're allowed to disclose something is if required by law, if you're ordered, for example, to go to court. But even then, you should give the party whose information it was the opportunity to go and defend the case in court to prevent it from being disclosed.
So it definitely seems that your NDAs is something that you should have in place. But now we've all heard about that please call me case where the employee sued the company for stealing his idea. So would this kind of action always apply to new products being developed for a company, or do I have the rights to this because it was my idea?
No, so this is a really important point, and I've heard highly educated people, including academics, having this strange concept that if they created something, they have some right to it. So I often hear this statement, but it's my work, I wrote it, or it's my work, I created it. People forget that as an employee, they are paid to do the work. And if it's in the course and scope of the work, then their employer is the owner thereof. When does that not happen? So an employment contract should set the boundaries, but these must be reasonable. So a contract cannot say everything and anything that you do or create while you're employed at this company will belong to the company. If, for example, you're a marketing person and you've created an electronic device in your spare time at home using your own tools. So what I'm trying to say here is that things that were made or invented by you outside the purpose for which you were employed and outside the course and scope of your employment, you may in fact have a right to. But anything which is within the course and scope of your employment definitely belongs to your employer. So in the Please Call Me case, an accountant came up with a technical solution to a problem. That accountant was not expected to do so. In fact, he was never hired to do so. He didn't sit in that department. And that is why, at the end of the day, the court held, amongst other reasons, that he, in fact, had a right to some remuneration for coming up with the Please Call Me idea. There were also other issues, as in the company had actually initially made promises to share its proceeds with him and so on, and then later tried to renege on it. What is the application of this in new product development? Well, new product development is steeped in IP and trade secrets. So you have new formulations, such as products, concentrates, etc. New processes, for example, the recent frequent use of high-pressure pasteurization on various products, new use of ingredients, there are new sweeteners, there are new preservatives coming out, etc. Now, the problem with all of these is that typically your laboratory staff have access to this intellectual property and the trade secrets. Why? Because they typically are the ones working with it while developing the new product, or alternatively, even in the form generating the formulation. There are other people that also have access to it, such as salespeople, food technologists, and others. You can imagine your technical sales staff are visiting companies and are now trying to convince them to use your new ingredient. They have this trade secret at their fingertips, but yet they need to be careful how much they disclose and how they disclose it. So, typical problem which arises is that an employee involved in the development of a product leaves and does one of two things: either starts his own business as a consultant or goes to work at a competitor. Of course, one can become two. So you can go off and start your own business as a consultant and then end up consulting to a competitor. And in fact, not that long ago, I was involved in a matter where this in fact happened, where a consultant had left an employee that had been in the company for many years, had developed many products for a company, left that company, became a consultant. Several years later, a competitor of the company where he had been employed got him to develop recipes for them. And it appears he simply went and reverted to the recipes he had done for the first employer and developed products for the second employer. A court ordered him to stop. Then you have a situation where a competitor launches a similar product, but you don't know how or why, because that's the other likelihood. You suddenly see a product appear in the marketplace and you're not sure why. And there I like to speak of the 3 X's rule. So the 3 X's are your ex-employee, your ex-partner, and your ex-wife. These are the 3 people that generally know all your secrets. And if you suddenly find that a competitor has launched an identical product to yours, you've got to think if one of those 3 X's exist and if they may have disclosed the information. If you then find that one of them has given this information to a competitor, you may be able to bring what's called a springboarding action in the High Court. What does this mean? It means that if I give somebody confidential information and then they use that information to develop a product, even if I haven't given them the whole product formulation, they have springboarded themselves into a position where they wouldn't have been if they hadn't had the information. And a court will in fact stop them. So the other possibility is that there was a breach of a restraint of trade and or a non-disclosure agreement, and somebody has given your confidential information away. The important thing is that as soon as you become aware of this, one has to act quickly to stop the competitor. You go to court and you get a court interdict. This has happened repeatedly, successfully. It can be done that you get a court order to prevent the competitor from using your trade secret. So how does one actually enforce the rights that you have in terms of your trade secret or your confidentiality? So one can go to the High Court, and in the High Court, you can get an interdict, you can get a claim for damages, and you can get your legal costs from the competitor. In many cases, a company would be happy literally just with an interdict, because the key thing is you want to stop the other party. The damages may not even have occurred yet. They will occur if the person is not stopped. But what will happen is the court will first of all have an inquiry as to whether the confidentiality clause or the restraint of trade is reasonable. If it is not reasonable, you will not get an interdict. So it's quite important that these types of documents are drawn up and are not so onerous that the court will throw them out. The second point is, was all the confidential information and trade secrets marked as confidential and identified as secret? Are they valuable to the company? In other words, if something has happened before, did you take action to protect your valuable property? Were disciplinary processes followed if an employee has leaked your information or appeared to try to say access your information? And then finally, you need to understand that you do have to take action. If you fail to enforce today, you will lose your rights tomorrow. Because if one person steals your trade secrets and you say, well, it's not that important. The second time somebody steals your trade secrets, the court will say, well, you failed to enforce last time. This wasn't important to you. They're not going to give you protection next time.
So Janusz, that what you've just mentioned now is extremely important, because in that slide, it tells you what you need to do to protect it if someone steals your ideas.
Absolutely, yeah. No, it's very important, and also warns you that if you don't take action today because you feel sorry for someone or you don't think it's that important, you may not be able to take any action tomorrow when a bigger person or a bigger competitor comes after your confidential information. So a company can sue a competitor that is using their trade secret under what is called unlawful competition law, because it's unlawful to use somebody's trade secret. But in South Africa, it's not a criminal offense as such. So there are many countries where there are trade secret laws, and taking somebody's trade secret is actually a criminal offense, and somebody could be jailed. In South Africa, that is unlikely unless theft of the trade secret goes together with, say, theft of a computer. I steal a notebook computer out of your car so that I can get to your confidential information, then obviously I can be prosecuted for theft of the computer, but not so much for theft of the confidential information. But definitely under unlawful competition law, I'd be able to get an interdict. If I can show what damages I suffered, there could be damages. And of course, there's always the legal cost, which can be very high. A court can order a company to get rid of an ex-employee who stole trade secrets, or to at least redeploy them in a different department. So I have hired your lab staff that developed your successful product. The court may order me to either fire those people, say they cannot work for me because they are in possession of confidential information and trade secrets, or they must be redeployed into a different division where that information cannot be used. And then, of course, there's always the PR angle, and one can publicize the fact that you got a court order against a competitor because they were stealing confidential information. So in conclusion, trade secrets are protected by good record keeping, solid contracts, valuing your trade secret, exercising confidentiality, and enforcement against abusers. And I think that last slide is just really important to bear in mind in your business. Thank you.
Thank you so much, Janusz. I really think, this is a topic where people sometimes neglect, that they don't look at it at all, and only when the pawpaw hits the fan, they go into it.
I have a question in connection with recipes and formulations where, a slight variation of a recipe that you may be using may be altered by somebody who had information about your recipe and use that for commercial purposes. So is there any action or is there any kind of enforcement that you can take if they signed a confidentiality agreement.
Yes. So you remember one of my slides spoke about the concept of springboarding. This is an exact example of springboarding. So you had a recipe and your employee or somebody signed a confidentiality agreement to keep your recipe secret. They then give your recipe to a competitor who doesn't make your product. What they do is they develop it further. In other words, they didn't start at the beginning. They started on the shoulders of your product. That is called springboarding. So you would be able to take legal action to get an interdict, possibly damages against the company that's using that information, but also possibly against the employee to prevent them from giving that information to anybody else.
Understood. Thanks.
Okay. Gordon, I see your hand is up. Do you have a question?
Yeah, I don't know if it's going to fit in with the discussion that we're having currently, but on your logos and that kind of thing, where would I thought you could register or patent your logo and that kind of thing. Does logo and something is weird. It's actually how it's made and how it's put together, your logo. Is that a trade secret?
No. Okay. So
and intellectual property that a person could register as a patent, or how about that?
Sure. Okay, look, I'm also a patent attorney, so I'll explain it to you. It's not a problem at all. So there are various types of intellectual property. One of them is called a trademark. So the logo that you're talking about, one would register at the trademark registry as a registered trademark. It's not a secret because obviously you're using it every single day on your letterhead and on your business cards and on your products, but it's protected because it's registered as a trademark. The trade secrets we are talking about, in other words, are things people can't see. You know, the Coca-Cola you buy, you drink it, but you don't know what the recipe is. So the recipe is secret, not the product.
Okay, perfect. Thank you.
Thank you so much for joining us today. We trust you found it valuable. Should you have any questions, please contact info@foodfocus.co.za and we will get back to you. Thank you.